ladies and gentlemen. The Deputy Chief Justice, who is also a Chancellor of this university, Justice Museneke, my colleagues at the Constitutional Court, colleagues from other courts, the university community, members of the legal profession, ladies and gentlemen, a good evening to you all. When you get a last-minute invitation to participate in a program, you can't help but have a nagging feeling that you were a last resort. That has not been the case with my invitation to come speak here. Advocate Stuart Wilson of the Socio-Economic Rights Institute, SERI, extended the invitation as far back as 20 August 2014. Thank you for that, Stuart. The problem with the early invitation, though, is that I have no excuse not to speak well. But please do not hold your breaths. Let me also thank SERI and the Vets History Workshop for organizing this very important conference. A conference at which the killings of August 2012 and all that is relevant thereto will be discussed. Killings that took the lives of 44 people in the space of only 5 days. Of the 44 people, 34 being killed by the police on 16 August 2012. I cannot but share that the hail of bullets that killed the 16, or rather that killed 16 of the 34, lasted only about 8 seconds. In 8 seconds, that many lives taken away. That by our law enforcement officers. This is the shocking, heart-rending, numbing scene that was shown on television day in and day out. Thus far, these killings are the darkest hour in the history of the democratic South Africa. They, and all that bears relevance to them, must continue to be a subject of discussion amongst South Africans. It is not enough that they are discussed in a commission of inquiry or in adversarial, party-focused litigation in courts of law. Ordinary South Africans must play a role in coming up with solutions that will help avert a recurrence of another Marikana. As I understand it, that is exactly what the conference seeks to achieve. It is for that reason that I am grateful to SERI and the Vets History Workshop for organizing the conference. The overarching features of the conference are not only the killings, but also the general conditions that miners find themselves in within the mining industry. Their salaries, the living conditions, the general socio-economic environment to which they are subjected. A not insignificant number of miners live in conditions of squalor, and whether out of choice or as a relic of our past laws that did not allow people from self-governing or quote independent close quote homelands or other quote black close quote areas to become the true South Africans that they in fact were. Many miners do not set up permanent homes within the areas where they work. They continue being migrant workers. That has serious implications for their family lives. They become absent spouses and parents with all the social, emotional, and possibly psychological ills attendant thereto. So you have a lot to discuss. Some of these other overarching features implicate, I'm not saying limit or infringe, constitutional rights. Whether or not rights are limited or indeed violated is something that will perhaps be deliberated upon at the conference. I consciously avoid going so far as to say they limit or infringe, because one has no control of what may get litigated before our courts. And I do not want to unnecessarily recuse myself. By way of a few examples on the implicated rights, one has in mind the right to dignity, the right of access to adequate housing, and some of the many rights conferred on children by Section 28 of the Constitution. It is not consonant with the right to dignity to live apart from your spouse and family, where that is not a conscious and true choice. And nor does it conduce to the enjoyment of that right to live under appalling conditions, where what you can afford or is available to you is the flimsiest form of shelter. The latter even implicates the right of access to adequate housing. It is not in the interest of the emotional and psychological well-being of children to live apart from a parent, and that is not in the best interests of a child. And it is also at variance with a child's rights to live in a family environment. These implicated constitutional rights, the Marikana killings, and more are worthy topics for deliberation. May all participants confer well. Although the focus of what I'm going to say is my experiences, thoughts, and perspectives on my involvement at the Marikana Commission, and the emotions that often engulf me, I have strangely titled this address, quote, "But it will never be played in my house," close quote. Try as hard as you may, you will never guess what that is about. By far, the Marikana brief surpasses all other briefs that I have held in my entire legal practice. It does so for a variety of reasons. The subject matter involved, the emotions it aroused, the sheer volume of material that we had to go through, and the complexity of parts of it, the unbelievable multiplicity of legal representatives, which entailed having to contend with the many and varied issues they often raised, some quite tricky. Right from the start, we had it rough, very rough in fact. Soon after his appointment, Judge Falam, the chairman of the commission, convened a meeting with all the participants. At the meeting, he set a date for the commencement of the commission hearings. That date was very close and left us with little or no time for meaningful preparation. At that stage, all that we had done was to structure how we proposed going about the hearings, even that very tentatively, because we were yet to A, go through the copious material that we were still to receive from the Independent Police Investigative Directorate, B, decide what other information we required, C, appoint our own investigators and assign them tasks, D, decide on what we wanted to prove, E, consult with witnesses, and F, finally decide on the order of witnesses that we would call, and generally how to go about with the hearings. We did not have that luxury, unfortunately. No amount of pleading and explanation would persuade Judge Falam to budge. In retrospect, he was right. The nature, magnitude, and gravity of the Commission's task required prompt action. Delays might have given rise to negative perceptions about the Commission. There were skeptics. Because of the near impossible position we found ourselves in, we approached certain individuals whose identity I will not divulge, who had had a head start for access to their information and evidentiary material. They were involved in private research or investigations. Their skepticism would not allow them to touch us with a 10-foot pole. Whether or not the skepticism was well-founded is for you to judge. At this stage, let me thank the other 6 members of the evidence leading team: Advocates Jeff Butlender, SC, Matthew Shaskalsing, SC, Kameshnik Pile, SC, who was then a junior, Charles Wesley, Matthews Mujapilu, and Tantaswa Lupuana, and of course our instructing attorney, Mr. Tobani Mpepu. I could not have wished for a better team. It was as a result of the ingenuity of the team and of course the cooperation and collegiality of the other role players that the first session of the commission commenced as scheduled. Call it kicking for touch. What we did was first to arrange an inspection in loco, which we knew would last all day. For a few days thereafter, we led about 4 police witnesses to testify on what I would call formal evidentiary material. They were crime scene experts and testified on their observations at the various scenes of the shootings, including evidence of recovered cartridges, bullet fragments, live ammunition, and an assortment of weapons like pangas, bush knives, knobkerries, and sticks, and positions of dead bodies. When we ran out of witnesses, we would schedule another inspection in loco. Lest I be misunderstood, these were not inspections held for the sake of it. They were necessary and would have had to be held at one point or another. It was their timing that served our convenience. All the while, we were deeply engrossed in preparations. With the exception of the first inspection, which we all attended, we would send only 1 or 2 members of our team to attend the inspections. The rest would stay behind preparing. It did not take us long before we were ready. Once again, I must acknowledge the cooperation of colleagues in the various legal teams. Some readily availed their quote-unquote witnesses for the hearings to start running in earnest. I say there in quotation marks because, truly speaking, the commission was at liberty to call whichever witness at whatever point. Unfortunately though, and obviously because of the sharp contestation, the legal teams had positioned themselves adversarially. Although that did have its disadvantages, it worked to our advantage in the circumstances, and I think it worked well. Imagine the mammoth task that would have confronted us if, over and above the witnesses that we as evidence leaders consulted with and called, we had had to do the same with the witnesses that were called by the various teams. That would have been a near impossible task. When people talk about the Marikana killings, what most have in mind are the killings of 16 August 2012. That is understandable because in one afternoon, the police, who we expect to protect us from general lawlessness, physical harm, and indeed even being killed by others, shot and killed 34 people and injured scores of others. Harrowing as that is, it should never cause us to forget the 10 other people who had suffered violent deaths only a few days before. That is a fact that cannot be swept under the carpet. Like those killed on the 16th, they too left behind loved ones. They too were fathers, brothers, husbands, partners, and lovers of people they left behind. They too loved life and all that it offers like the next person. It is for that reason that as evidence leaders, we had to do our best to ensure that each story was told and each death accounted for. I now proceed to deal with the killings. On this, I want to tread cautiously because the commission is yet to pronounce on them, or has pronounced, but the report is yet to be publicized. And there are pending criminal and civil proceedings that pertain to the killings. But I will not be so cautious as to end up saying nothing meaningful, as to end up not saying anything meaningful. Why should I be here at all if I won't say something meaningful? For the conclusions that I draw, my approach is, as best as I can, to rely on objectively incontrovertible material and adverse information obtained from the very people against whom I draw my conclusions. The first casualties were Mr. Franz Mabelane, Mr. Hassan Fundi, and Mr. Tapelo Mabibi. They were all killed on Sunday, 12 August 2012. Mr. Mabelane and Mr. Fundi, both Lonmin security guards, were hacked to death and set alight. A piece of flesh was even cut off the face of one of them. They suffered those brutal deaths at the hands of the striking workers. Mr. Mabibi was at work at Lonmin's K4 shaft. Men with faces covered in balaclavas arrived at the shaft. They attacked workers they found at work, fatally injuring Mr. Mabibi. They also set alight Lonmin cars they found there. About the identity of these men, all that I will say is this. For a strike to be effective, workers, or at least a significant number of them, should not go to work. Put differently, it is not in the interest of striking workers for the workforce to continue going to work as if it is business as usual. It is not surprising that the Lonmin occurrence book had several entries of reports of violence and intimidation against workers that continued working. That said, your guess is as good as mine as to who it is that killed Mr. Mabibi. A total of 6 people were killed on Monday, 13 August 2012. Mr. Julius Langa, a non-striking worker, was killed on his way to work in the early morning. He had 18 incised wounds on the chest, upper limbs, back, head, and face. Concerning his death, I would make similar observations as those I made in respect of Mr. Mabibi. The deaths of the other 5 people were connected to an incident during which 2 police officers were killed by strikers. I say more about this incident later. The 5 were Mr. Pumzile Sokanyile, Mr. Tembekile Mati, Mr. Semi Jokanisi, Warrant Officer Sillo Lepaku, and Warrant Officer Tsietsi Munene. The last and 10th person to die before the killings of 16 August 2012 was Mr. Isaiah Twala. He was a Num shop steward. His body was found behind the huge rock outcrop commonly referred to as the Kopi, at which the striking workers used to gather on a daily basis. This was on 14 August 2012. He sustained multiple stab wounds on his torso and had a wide gash down one side of his face. An eerie sight was the skull of a cow that had been placed on his chest. When the strike started a couple of days before the first killings, the strikers were unarmed. Why they armed themselves is a hotly contested issue. They claim that they armed themselves in fear of NUM members who had fired shots at them on Saturday, 11 August 2012. NUM members admit having fired shots at the striking workers. However, in exculpation, they aver that the strikers were armed and approaching the NUM office to attack the NUM members. I will not even begin to express a view one way or the other on these facts. Suffice it to say, the reality was that the strikers were armed as from the weekend of 11 and 12 August 2012, and people were dying. They were armed as a matter of course and always gathered on the Gopi armed. In terms of Section 12, read with Section 8 of the Regulation of Gatherings Act, it is a criminal offense for a participant at a gathering or demonstration to have in her or his possession a dangerous weapon. Because people were being killed, and because of the provisions of the act that I have just mentioned, the police were obliged to disarm the strikers. But the big question is, how? The first attempt by the police to disarm the striking workers was on 13 August 2012. That day, a breakaway group of strikers were observed sitting next to or on a pipeline in the vicinity of the K3 shaft. At this stage, let me interpose and say the public order policing or crowd control prescripts of the South African Police Service enjoin the police never to walk into a crowd control situation without some planning. Of course, the degree and extent of planning will vary according to the nature of what is confronting the police and the time available to plan. The one exception to this prescript is where a crowd control situation is spontaneous or happens unexpectedly and requires prompt action. Let us look at what happened on 13 August 2012. When the breakaway group of strikers were returning from K3 shaft, the police intercepted them along a railway line. The police admit that they had not planned for this encounter with the strikers, but claim that the strikers' conduct was spontaneous. Consequently, they had no time to plan. This claim is doubtful. Doubtful because it took the strikers some time to walk from the pipeline to where they were stopped by the police. The copy that the strikers were apparently walking back to was still a considerable distance away. If the police felt that they had to intercept and disarm the group, they did not have to do it at that spot and nowhere else further along the route. They could have delayed the interception, thus giving themselves time to plan. Of course, the time for planning would have been limited. But it would have been better than no planning at all. I put this no higher than that. The claim of spontaneity is doubtful. An amicable request by Major General Mpembe that the strikers should surrender their arms did not bear fruit. What the strikers did instead was to walk away. What is of grave concern regarding the interception is the manner in which the police then implemented the operation. It was a disaster. This I say based on A, objective facts, and B, what some SAPS members said. Before I get to the detail, let me indicate what SAPS says precipitated the killings. The police say that when the breakaway group of strikers left the railway line, they, that is the strikers, walked across an open field that is adjacent to an informal settlement. The police say they harbored a fear that if allowed to enter the informal settlement, the strikers might injure people and damage property in the settlement. They claim that the strikers suddenly veered off their course and proceeded towards the informal settlement. Because of this, the police fired rubber bullets and stun grenades at the strikers to prevent them from entering the informal settlement. According to the police, the strikers then attacked them, killing 2 police officers. What happened, and I say it with no fear of contradiction because it's there, it's on video. The strikers left the point at which they had been intercepted. They walked across an open field. The police were following, some walking to the side. A police inyala, which is an armored police vehicle, drove on the right of the strikers, or to the right of the strikers as they were walking, cut in front of them, and came to stand at the front, but to the left of the strikers. The informal settlement that I have referred to, and which the police say they wanted to prevent the strikers from getting into, was to the right. Now mark this. This Inyala drives to the right, cuts in front, and goes and comes to a standstill to the left, somewhere in front. Out of that Inyala came a couple of police officers, and they fired tear gas canisters. The protesters continued walking, following the exact same direction they had been following before the tear gas canisters were fired. And then a stun grenade was fired. We were told in evidence the sort of effect that it has. You actually feel it. You can actually feel it on your body. And once the stun grenade was fired, a commotion started. The strikers started running away, or running all around, and after it all, at the end of that commotion, 2 police officers were dead, and 3 civilians were dead. That is what happened. Now, crucially,
sorry, apparently this is the correct video. It's a bit later on. Apparently this is the correct video. It's just a little bit later on. Okay. So I can play it if you'd like.
Now, in addition to this objective material, 2 of SAPS's own officers gave evidence that contradicted the claim by SAPS. Lieutenant Colonel Vermaak testified that he was in a helicopter that was flying above the strikers and police to observe what was going on. He was surprised to see tear gas and stun grenades being fired at the strikers because at that point the strikers were walking, quote unquote, peacefully. He used the Afrikaans word for that. He expressed his surprise to Captain Lust, who was with him in the helicopter. Lieutenant Colonel Vermaak did not observe any significant change in the course followed by the strikers. Captain Lust confirmed the testimony of Lieutenant Colonel Vermaak. It would be of interest to view an aerial photograph of the area. And whilst we are looking at that, I may say, all of this raises questions then. If according to Lieutenant Colonel Vermaak and Captain Lust, there hadn't been any sudden veering off course by the strikers, for what reason then had the police started firing? That is what triggered the commotion, and that was the proximate cause for the killings that ensued. I'm not saying that to condone the killings, but it was the disastrous action of the police that caused it all. If you see this, this yellow oval here, this is the field where the strikers walked. And roughly that is where the skirmish started. And the blue circle there is the copy to which the strikers, or rather at which the strikers used together, and to which it seems to be common cause that this breakaway group was walking to on the day. Witnesses that we as evidence leaders consulted with told us that going to the spot from which they were now coming, the strikers had followed this route, going there. The informal settlement that the police were talking about is here, right here. So coming this way, they had walked right past that informal settlement. General Mpembe, who was in charge of the operation, made a statement soon after the incident. In it, he did not mention that the police had fired tear gas and stun grenades because the strikers had abruptly veered off course in the direction of the informal settlement, which the police wanted to protect. It was in a statement made much later that General Mpembe for the first time made this claim. In any event, the claim by SAPS is nonsensical. It is not disputed that some of the strikers lived in the informal settlements in and around Marikana. On a daily basis, they left these settlements in the mornings and returned to them in the late afternoons or evenings, armed every day. SAPS never pointed to any incident of the nature they claimed to have harbored a fear for. Yes, people were being killed, but that did not happen in the circumstances that SAPS were now wanting the commission to accept. This is the incident that left 5 people dead, 2 of them being police officers. For the reasons that I have given, a significant amount of blame for these deaths must be apportioned to the police. But the strikers were also to blame for the deaths. They were going about bearing weapons unlawfully and refused to surrender them when General Mpembe was pleading with them to do so. Some earnest peaceful attempts to disarm the strikers were made by the police. One example is the very attempt by General Mpembe at the railway line on 13 August 2012. Another example comprised discussions that lasted an entire afternoon between a police negotiator, Lieutenant Colonel McIntosh, and representatives of the strikers. This was on 14 August 2012. This too was without success. Coming to 16 August 2012, there is so much to say, but time does not permit. I will focus on a few aspects. On that day, the police engaged in what they referred to as the tactical phase. The aim is said to have been to roll out barbed wire between the police and strikers, disperse the strikers into smaller groups, and disarm and arrest them. This plan had been put together in great haste and for use within a very short space of time. That, in such an extremely volatile situation involving thousands of strikers, estimates varied from 2,000 to 5,000. I will not get into the detail of the planning. What I will touch on instead are a couple of issues as the police implemented the plan. When the police Inyalas began laying the barbed wire, the strikers moved in the direction where this was taking place. The strikers' explanation is that they wanted to walk past so as not to be closed in. The police, on the other hand, say that the strikers were intent on attacking them. How this unfolded is best illustrated by an aerial photograph. That's the barbed wire. And as it was being laid out, the strikers moved across towards the Inyalas, but because the wire was being laid down, they couldn't go through. So they kept doing this, making those curving movements until in the end they had to come round this cattle crawl, round here. And here there was a line of the TRT police, or the Technical Response Team of Police, who were forming a line across like that, holding R5 automatic rifles. And what we see on this one, so in the end, in the previous slide, the barbed wire had not gone all the way. In the end, it came all the way to the stop crawl. And that is why the strikers had to go round this way. And why do they say they wanted to go round? I will explain that a bit later. Here, there is a, here is the line. It's actually showing the TRT line. There it is, the Technical Response Team. And here, there's a fence, and this fence is in the Nkaneng informal settlement. And here, these were police vehicles, Inyalas and Caspers. And the strikers came around here, and as you can see them there, it's already after the shooting, and they've fallen down on the ground and have been shot. Now, let me show you what happened just before the 8-second volley of gunfire.
Tightly packed and staying low to the ground, with spears, sticks, and machetes.
Just pause.
South African
Just
police
pause.
forced these miners into an area with razor wire.
And let me explain this. The police, or rather what we would be shown on TV and what news commentary would say, was that one of the strikers had fired a pistol, and that it was as a result of that that the police then shot and killed the group of strikers. And in fact, they said the strikers ran towards the police, intent on attacking the police.
Then this happened.
Yeah, no, just pause it there, Ruben. Yeah. Did you see the police between these armored vehicles? Did you see them? I hope you noticed them firing guns. Now, there are the strikers. They've come round the stock crawl, and there is the crawl. There is a gap here between the crawl and these vehicles. Continue. Yeah, the police are continuing to fire.
Oh, then this happened.
The gentleman crouching here is the one who took out a pistol and started firing. But what I would like you to take note of is that he did that after the police had started firing at the strikers. It is not him who fired with no shots being fired at all. The police were firing, and it was only thereafter that he took out his firearm and started shooting. That is how things unfolded. And then, after that, they start running. There's fire coming from here. They start running. And one can infer that they were running because the police here were firing shots at them. But the police standing that side claim that the strikers were rushing towards them to attack them. If my recollection on this is correct, a SAPS member admitted that the sound of shots fired from rubber bullets and metal bullets was similar. That means when the police fired rubber bullets, that is, the police were between the armored vehicles, were firing rubber bullets. That's common cause now. That means when the police fired the rubber bullets from between the Inyalas, the strikers could not have been able to tell the difference. To my mind, that explains two things. First, the striker who discharged the firearm did so as a reaction to the gunfire directed at them. Second, the strikers probably, or at the very least, possibly started running towards the TRT police line, fleeing from the rubber bullet fire. The next thing that happened is that 16 striking workers were killed in an instant. Immediately after the killings of 16 August 2012, what we were shown repeatedly on our television screens was only the killing of 16 strikers next to the cattle kraal. What South Africa and the world never saw was the shooting of other strikers at another kopie, the second kopie, and the killing of 18 of them. This second kopie is wooded and has rocks and crevices. After running away from the scene of the first shooting, some of the strikers came to hide in the second kopie. The police pursued them. Initially, SAPS claimed that the police had fired shots into the kopie because the strikers were shooting at them. But when it became clear from the evidence of the police crime scene experts that inside the copy, no cartridges likely to have been ejected by firearms fired by the strikers had been picked up, SAPS suggested that those cartridges might have been trampled into the ground by the vehicles of emergency medical personnel, who, it is common cause, had driven through the copy to attend to the injured. Because of the terrain, these vehicles would have had to follow roughly the same track. It would have been quite a coincidence that all cartridges ejected by the strikers' firearms would all have been on that track and been driven into the ground. Without any prompting and probably realizing the implausibility of their suggestion, Substance defense later metamorphosed. To take one step back, the police approached the second copy from more than one direction. In the end, this copy was roughly surrounded by police. The new defense was that when police on the one side fired shots, those on the other sides responded by firing shots into the copy, not realizing that it was, quote, friendly fire, close quote, and believing instead that it was gunfire from the strikers. As a result, shots were fired from all directions into the copy. A case of putative self-defense, perhaps? Of course, SAPS did not abandon self-defense completely. Some strikers came out of the copy running and were shot dead. The police claimed that these strikers were not running away but charging to attack them. Those people are dead and cannot tell their own stories. I will not attempt to resolve this factual conundrum. Suffice it to say, it escapes me why SAPS's position on this incident, which took as many as 18 lives, morphed as many times as it did. Crucially, 2 senior police officers had foreseen bloodshed if an attempt was made to disarm the strikers at or around the copy. These were Lieutenant General Mbombo, the Northwest Provincial Commissioner, and Major General Mpembe, a Deputy Provincial Commissioner, Operational Services. At a debriefing session he held on 15 August 2012 with NUM, General Mpembe said that if the police were to go to the copy to disarm the strikers, people would die. His exact words as he addressed NUM officials, including its national president, were, quote, going there to the mountain, that is what he called the copy, disarming people, it is going to be bloodshed. It is going to be bloodshed. He said it twice. That one I can assure you, close quote. How ominously prophetic. Of course, when he testified, he tried to suggest that he did not really mean this and had merely said it as part of an attempt to convince the NUM officials to intervene and help bring the strike to an end. On the previous day, 14 August 2012, Lieutenant General Mbombo had met Lonmin management. Apparently, unbeknown to her, an audio recording of the discussions was made. During the discussions, she said that if on the next day the strikers did not let the police disarm them, open quote, then it is blood, close quote. Under cross-examination, she was more explicit. She said that if the strikers did not lay down their weapons, there would be injury or death. The strikers did not surrender their weapons, and the police proceeded to the tactical phase whose aim was inter alia to disarm. This raises some questions. Between the time Generals Mbombo and Mpembe said that a forced surrender of arms would result in death and the time the tactical phase was implemented, had the police done anything to avert the foreseen death? If not, had they simply resigned themselves to death eventuating? If so, did they have any idea of the likely death toll? Were they even concerned what the death toll might be? General Mpembe's prophecy, if I may call it that, was made as late as 15 August 2012. the day before the mass killings. I am not aware that between then and the implementation of the tactical phase, something on the planning front that would have allayed his fears had since come up or been done. It is not surprising that on 15 August 2012, General Mpembe made a recommendation to General Mbombo for a cordon and search. This was not to be a cordon and search of the copy where strikers used to gather. It was to be a cordon and search of the Vonderkop and Carrier mine hostels and the adjacent Nganeng informal settlement. An affidavit supporting the recommendation conceded that, open quote, conventional policing methods, close quote, could not address the problem or prevent possible bloodshed. The cordon and search was planned to take place somewhere between 12 midday on 15 August 2012 and 12 midday on 16 August 2012. I am no expert in policing, but depending on the timing, the cordon and search was less likely to encounter serious resistance. Key to it would be the element of surprise and the courage born of being part of a large armed group would be lacking if the cordon and search was timed carefully. It was a marvel to watch the many highly skilled colleagues in the various teams displaying their forensic skills. Sparks would often fly amongst us, and on occasion, I would be in the middle of it. But as the professionals that we were, and some still are as practitioners, we would quickly smoke the peace pipe and move on. I just must share an exchange that took place between Advocate Dumisa Nsebeza SC and me. Advocate Kameshni Pillay SC of my team had an exceptional ability not only to keep the tally of the Commission's extraordinarily long list of exhibits, but also to remember what exhibit was what exhibit number. One day she was not at the hearing. Bradin Nsebeza, as he is popularly known, was cross-examining or leading a witness. Without having given us advance notice, he referred to an exhibit by description and expected us to have it ready for him to use. At that stage, the exhibits were running into very high numbers, extremely high numbers. With the exception of Advocate Pillay, that was a near impossible request in the time available. In what I thought would be an effective witticism, I said, quote, with all his attributes, even a Houdini may fail sometimes, close quote. Not uncharacteristically, Brady came back with an instantaneous retort to my chagrin, of course. Quote, I must confess to have been spoiled by a more competent Houdini in the form of Miss Pillay, close quote. Two colleagues in particular gave me an extremely hard time. They are Miss Kathleen Hardy of Carl's in this very institution and Miss Nomzamo Zondo of Seri. I hate correspondence and I hate it with a passion. Miss Hardy and Miss Zondo each sent me correspondence every other day. I can only say I hope my responses were to their satisfaction. And let me thank them for keeping us on our toes and focused throughout the commission process. At the hearings, there would be moments of laughter as well. Growing up at Njijine, a rural village in the small town of Mount Frere in the Eastern Cape, we used to be regaled with tales of the prowess of Amampondo in conducting their own criminal defenses in court, all probably urban legend. But on this one occasion, I came very close to believing the stories. Mr. Sipete Pacha, one of the strikers who hails from Emampondweni, was in the witness stand. Advocate Ishmenya SC was cross-examining him. Mr. Pacha's testimony was suggesting that he had not observed something. In his characteristic, effective, incisive style of cross-examination, Advocate Semenya asked him a few questions which individually seemed innocuous, but cumulatively eventually drove Mr. Pacha to a corner. Advocate Semenya SC then delivered the coup de grace. There just had to be one answer, and it had to be that Mr. Pacha had in fact observed what he had earlier claimed not to have observed. And at this point, I would ask sensitive listeners to block their ears. Without batting an eyelid, Mr. Pacha said, open quote, "Kaloku ibhoshi iyachisa. Xa ikuchisa kufuneka uyobhosha ngoku," close quote. Roughly translated, he meant shit can really burn you. And when it does, you just have to go now, close quote. The clear implication was that he had suddenly had to go relieve himself and had thus not observed what Advocate Semenya wanted him to admit to. And that took Advocate Semenya off guard. On the odd, very odd occasion, we would relax. We had our resident DJ. That was none other than Terry Mutau SC. On the occasions when he would be DJing, if there is such a verb, at the News Cafe in Rustenburg, he would invite us. On one such occasion, he had invited Advocate Skalkberger SC. Advocate Mutau had said that he should come listen to house music. When Advocate Mutau took position at the decks and started playing, Advocate Berger, who up to that stage had been sitting down, stood up and went to watch Advocate Mutau up close. He then looked at me and asked, quote, "So, is this house music?" close quote, to which I answered in the affirmative. He then said, quote, "I see, but it will never be played in my house," close quote. I hold no brief for the commissioners, but I want to say this. One often encountered members of the public who expressed the view that the commission was taking an inordinately long time to finalize proceedings. There was serious contestation, and any significant curtailment of proceedings could easily have been perceived by some as being partial to the one or other party. Personally, I would not fault the commission for the time it took to complete its mandate. Needless to say, our task entailed trawling the material with all sorts of harrowing stories and gruesome photographs. It was emotionally draining. Communicating with me, one of the evidence leaders, Charles Wesley, said, open quote, "I must confess that even after 2 years of looking at the events that unfolded at Marikana, they still deeply disturb me. Marikana is not something that easily fades into memory, but maybe that is how it ought to be," close quote. I share those sentiments completely. Thank you.